This is Jesse Fenty. I am a patent attorney out of Washington, D.C. I have a degree in electrical engineering from Howard University, a law degree from American University. I'm currently the programs chair of the IP SIG. So NESB Professionals has, at the professional level, has a different organizations called special interest groups. And so the intellectual property special interest group is fairly new, but we in the group, myself and Braxton Davis, who was the director, we kind of feel like IP is the center of the universe. And so we were very excited about intellectual property. And as I'll talk about in this presentation tonight about, we think IP is missing in a sense from the engineering discussion. And then I also have on my slide here that, so I'm in Region 2 in DC, and I put my name in the ring to be entrepreneurship chair for Region 2 this year. After we have the national convention, we'll see what happens. But I think IP and patents and engineering has a lot to do with entrepreneurship, and we like to bring that to NESB, bring the entrepreneurship aspect of engineering to NESB. So moving along, so I'm going to talk about tonight what's missing, in my opinion, and in some people's opinion. What is a patent? There's a lot of discussion about patents and trademarks and copyrights and intellectual property, but what is a patent? So we'll talk about that a little bit. Why are patents important for engineers? And then others talk about other aspects of IP in terms of trademarks and copyrights and other things that are important in business. So what's missing? So in your engineering education, when you think about education, what's taught in engineering school, is that the entire picture? Is that the entire picture of engineering? What you should get, what you could get. I mean, employers will hire you to do, manufacturing, to do development, to do product design at their companies. And so, in engineering, you're taught basic concepts, but is that all there is to it? And so certainly tonight we're gonna talk about that. We think patents is missing, the actual aspect of patents. But the part of business is important. The part of law is important. So there's an aspect of this. Go back for a second in terms of the purpose of engineering. So what's the purpose of engineering? And so what's missing is the patent aspect, the business aspect of engineering school. And it's no fault of anyone's in particular. The way engineering has evolved, it evolved out of, and I have a second presentation. We'll get to this after this presentation, but engineering kind of evolved from the development of science. And so early on in England and in France, when people came up with new science and new discoveries of materials and magnetism and electronics and motors and so on, they would publish their ideas in technical journals. And so that's kind of what professors do in law school. They're PhDs that understand engineering at the highest levels. And so when they come up with a discovery, when they come up with something new, they publish it in journals. But they're not business people per se. So that's why companies will come in and hire engineers to make products, but the business aspect of engineering isn't often taught in engineering school. So that, in a sense, is I think what's missing and why engineers have missed out on the patent doctrine for so long. So the purpose of engineers in engineering is to solve problems. I mean, my intro to engineering class at Howard University Engineering School, the first class was, one of the first questions was, what do engineers do? I mean, engineers solve problems. That's what we do, and there's no particular way to solve a problem. I remember the professor saying that you can have an electronic circuit with 2 chips, or you can have it with 10 chips, and there's no right answer. It just depends on the design. And so I have the picture here of problems and solutions in science fair. So in a sense, when I look at engineering, when I look at science, when I look at problems and solutions, I just see one big science fair. I see us doing a science fair project in the 4th grade and the 8th grade, and senior year, high school, and undergrad, and grad school and at the professional level, I see that all kind of the same process of looking at the background, looking at the problem you're trying to solve, looking at what the problems are, and then looking at what the solutions are. And I remember even seeing the recently I looked back and looked at the product launch of Steve Jobs in 2007 when he launched the iPhone. He did the same thing. He just talked about what the problems were and what the state of the art was, and then he gave his idea for the smartphone and what was going to be the new wave. So it's all one big science fair, in my opinion, engineering. I mean, to boil it down to look at it in a general sense. And so the engineering companies will hire us to solve problems, to develop new ideas, to manufacture, and to patent new products. And we're going to talk about patents tonight and other IP. And so I have almost everything you learn in engineering school. So when I work on a patent application, so I've been working for about 20 years in patents. I was a patent examiner at the USPTO for 9 years, and I worked in semiconductor processing and semiconductor devices and integrated circuits and capacitors and MOSFETs and all that kind of stuff, real fun stuff. And then I went to law school while I was in engineering, when I was a patent examiner, and I left the PTO back in '07, and I've been doing patent law. So I guess that's 13 years now. And I did 3 firms, and right now I'm working on my own firm, and I do teaching. I have a company called Endless IP, and I teach patent law, and I teach it to engineering students because I know that it's missing, and I'm active in the educational community. But when I work on a patent, if someone gives me an invention, I have to use. I mean, this is true for every aspect of engineering. This isn't just true for patents, but everything I work on for an invention is I have to use everything I ever learned in engineering sometimes. I mean, it may be optics, it may be something I had in physics 2, optics that I barely even remember, something dealing with ultraviolet light or some sort of signals and systems or some bit of chemistry or something. So, I mean, it's a fascinating process, and it happens in all engineering, but it happens in patents as well. And so I'm going to talk tonight about how engineers can get involved in the patent process and where engineers fit in the patent process. And so I'm just kind of talking about patents now, but let me go to an example patent just to kind of show you what I'm talking about. Let's move my screen here. So this is a patent document put out by this company ABB Schweitz. It's a Swedish or Swiss company, and so this is an electrical patent, electronic charger for here's the title. And so this patent came out February 25th, 2020. And so patents come out every Tuesday, every week. Every week, the U.S. Patent Office, and I'm just talking about U.S. patents in this demonstration, this presentation, but there's all kind of patents across the world. Every country, every major country has their own patent office. Then the European Patent Office has a kind of a group. European Union has a patent office. China has a big patent office. The big 5 are China, Korea, Japan, the EPO, which is the European Patent Office, and then the U.S. Those are kind of the 5 major patent offices in the world, and patent law is national. So if you get a U.S. patent, it's only enforceable in the U.S., but there's other ways there's ways that those countries have set up agreements between themselves to protect each other's patents and to apply for each other's patents. But this is a U.S. patent. This one we're looking at right now. And so there's a lot of information on this first page. The inventor is Bianco et al., and it's kind of this Latin phrase. So these guys are all Italian inventors. So very likely this company has an Italian design firm in Italy. And so this patent came out February 25th, 2020, for electronic charger for electric power distribution, installations, and a control method thereof. That's the invention. And so there's a bunch of information. This patent was filed. It's a PCT. It's an international application. It was filed probably somewhere in Europe in 2016, and then it was filed somewhere else, maybe in the U.S. in 2017. And then there's an abstract, which is kind of like what you see like in any science aspect. And what made me want to start teaching this course about patents to engineers, when I started seeing in my practice kind of like basic circuits in a way. So anybody who's an electrical engineer will recognize a circuit like this, having an input and output, and having some the signal being being driven and being filtered in a certain way. So so patents aren't always the most, the highest level of engineering out there. Sometimes they're just basic circuits for charging or for just for power flow, and that's what this one is.
Hey Jesse, can I interrupt you real fast? They're saying that they can't see the patent; they just see the slideshow, the PowerPoint.
Oh, oh, really?
Yeah,
All right, that's not good. Maybe I could have. All right, I'll get back to the slide. They can see that, right? The slideshow.
yeah, we see your slideshow. If you want to share something else, you have to go back into your share and share that particular document or other screen that you were sharing.
Do you know where to share? For new share.
Yep,
Oh, okay, let's see. All right, you can see it now, right?
yep. I don't know if you need to rotate it, but yeah, we can see it.
All right, so all right, I'll go back up. So then to go back to the PowerPoint, I have to do share again, or can I? Can you
No,
see that?
you have to share again to go back to the PowerPoint. You can only do one at a time.
Oh, okay. All right, good point. It's always a learning process. Let's see, where was I? Okay, the patent. Okay, so this is the patent I was talking about. A lot of information with no video. So all right, so this is the patent I was talking about. Um, February 25th, 2020, it came out. This is the inventor Bianco. These are the group of inventors. They always say et al, and they always list the first guy. So if you have a group, so most, there's a book out called The Innovators that was put out by Walter Isaacson. He wrote the Steve Jobs biography, and he wrote a book called The Innovators that said that most inventions are developed in groups. And I think a lot of people would agree to that. So a lot of the patents that you'll see in the world, you'll see et al. And that just means that these guys working on some team, and they're all working on electronic chargers, and they're all working on electronics for ABB Schweitz, and they're probably listed on who knows how many patents. So this is kind of like the face of a patent, a lot of information about it. And then so this is the electronic circuit I was talking about. So any electrical engineer could see this and recognize kind of what this is and maybe figure out what it is. And so a patent document will be, and I'll talk about this in a moment, but this is an engineering disclosure. So, I mean, engineers have to have a fantastic way to get into this patent field. So these drawings are sideways, but this is not so much, important in a way. I just want to show you what a patent looks like. So a patent will always have engineering drawings, and this is an electrical patent, so it'll have electrical patent drawings. And then after that, you'll scroll down, and then it'll have your description. And just like I said about the science fair, you'll have your background. Your background will tell you what's the problem they're trying to solve. The present invention relates to electronic charger for electric power distribution installations operating at a medium voltage level. Okay. And then the summary, the main aim is to provide an electronic charger for electronic power distribution at medium voltage level that allows overcoming the drawbacks of the known art. And so you have a problem and a solution, and then you describe it. And so this is what so this is what I do as a patent attorney and as a patent agent, as other patent professionals. This company will form a relationship with this client, and they'll have their inventors talk to me, and I'll get the disclosure, and I'll write this up. And based on my engineering knowledge, as I was saying earlier, based on everything I ever learned about power systems and voltages and current, sometimes I have to go back to my undergrad and learn some more things. But I'll write this up and describe how it works. And at the very end, there's a section called the claims, and this is the legal aspect. So a patent document is a legal document and an engineering document. So this section right here says the invention claimed is. And so what comes after this is the legal coverage for this patent. So everything else before that just kind of describes this whole power system. But what's actually claimed is the actual legal protection that this patent is getting. And this is the claims. And this is the part that's litigated. It goes to court. This is the part the patent office looks at the most. They look at the whole thing. But this is these claims. It's one claims, and there's down to maybe there can be 20 basic claims. So this patent has 15. So this 15 claims like the legal coverage for this patent. All right, let me go back to my PowerPoint. New share. Let's see. All right. Can you see that, Maurice, the PowerPoint?
Yes, sir.
All right, we're back. Okay. We're back. And so sorry, example patent. So then, okay, so what is a patent? So as I just said, it's a engineering disclosure. You have to, with a patent, you have to explain what it is and how it works. You can't just have an idea for something, just an idea. Like if I say I wake up in the morning and I say blue light and all the lights in my house turn blue, that's just an idea. And if I don't know how that works, if I don't know how to configure my electrical wiring or I don't know, maybe it's just to put the blue light on, who knows what. But if you just have an idea for something without being able to explain it, that's not you can't get a patent for that. And that's where I'm hammering this point about engineers, but that's where the engineers come in, because the engineers can explain. The engineers are taught in undergrad and grad school how things work. And so in my opinion, every engineer should come out of undergrad filing for a patent application. Your capstone project and your senior design class, you should be turned into a patent application. You should have on your resume that you filed for a patent, and hopefully you'll get it. I mean, it's a process, but it's a learnable process, and it's a powerful process. The second aspect of what is a patent is it's a legal document. It's property. It's and I'll talk about different kinds of property in a minute, but it's a legal kind of property. It's actually something that you can do something with. And the third part is it's a contract with the government. And this is kind of fascinating, because when you come up with an invention, when you invent something, in a way you want to keep it secret. You don't want anyone else to do it, anyone else to know how you did it. But society has this way of kind of coaxing this idea out of your head, because they want society to progress and to evolve. And so there's this contract with the government that if you tell the government how you made your invention, they'll give you this monopoly. They'll give you this patent monopoly. Right now, the law is 20 years from the date of filing. So you filed it today, whatever today is, March 17th, I think, 18th. And so from the day you filed today, you have 20 years to enforce your patent. Of course, it takes 2 or 3 years to get through the patent system. So in that sense, you'll have about 17 years to enforce your patent. And that's the law, and that's been the law for a while, and it's pretty good. So in exchange for you telling your idea, you disclosing your idea to the patent office, they give you in return this patent monopoly, and they protect it because it's a legal document. They protect it. And so the history of this was set out in Article 1, Section 8, Clause 8 of the Constitution. And this is the only time the word right right here, was used in the Constitution before the Bill of Rights was added. Bill of Rights is, the right to free speech, the first Bill of Rights, and then bear arms, and so on and so forth. Those are the Bill of Rights. But that was 1791. And 1787 was when the Constitution was actually signed, and the word right was only used once, and it has to do with patents, which is pretty fascinating. So the Congress shall have the power to promote progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the inventors authors is copyrights, and the inventors is patents, is patent holders. So trademarks came later. Trademarks came in a federal act, but the original protection out of the Constitution was for writings, for anything written in a book or a poem, and inventions. And so the rationale was that they knew early on. So the even though 1787 is early to us, but to them, I mean, slavery had been going on already since, in the U.S. since 1619, and the European countries since Portugal in the 1400s. So a lot of wealth was being created, a lot of invention was being created. The U.S. was a new world, and they knew the innovation was kind of like going on. And so the bargain back then was to put this in there to incentivize people to create. And the original rationale, which still holds true today, is that they thought if someone came up with an invention and made a bunch of money off of it, that other people would come up with other ideas, and as well, it would incentivize people to innovate because of making money. And so, in a way, even though people see it as a capitalistic kind of a theory, it's really socialism. It has its socialistic socialism in a way that these inventions are for the greater good. They're not just for one person, because one person has an idea, they form a company, and then those ideas help society. So it's a way of kind of using capitalism to achieve socialism. I'm not an economics major, but that's kind of how it works. And it works to this day. There's people who criticize the system, but it has helped society progress to the state that it's in now. So who knows if that's good or bad, but that's where we are. Um, how many types of legal property are there? And so so this actually was a lecture I gave at Johns Hopkins a few weeks ago. I'm used to speaking to audiences and having a little participation. So this is different, actually speaking. And I feel like I'm speaking a little fast. Let me slow down a little bit. So how many types of legal property are there? There's three. There's real property, which is your house, your apartment, land. It's called real property. That's why they call it real estate. Real property. Then there's personal property, your cell phone, your computer, your clothes, your bicycle, your car. And then there's intellectual property. And they all have similar characteristics. They can be bought and sold. They can be licensed. You can rent out your property. All different kinds of property have the same aspects. And so that was the big difference in the U.S. between the U.S. came up with their own law, with their law of 1787, because in England and France before that, to get a patent for, say, to make steel or to make guns or to make whatever, you had to get a grant from the crown. And so there was only certain ways you can get patents back in old England, and that was just having a relationship with the crown, with the king. But those patents, those rights to make certain things couldn't be sold, couldn't be licensed from one person to another. They were very exclusive and very limited. So the U.S. system was set up for that individual freedom, for people to be able to exchange their intellectual property almost on the open market. And that's kind of how it is now. And so other aspects, like I said before, intellectual property, there's patents, trademarks and copyrights, and we'll get to that. So what's in it for you? So this is just, this is all well and good. Thanks a lot, Jesse, for this information. It's cool to know, but then, so what, what's in it for you? And so, and I had this slide later on, but I moved the slide up because I was, said it's more important. So for you all, you listening, I appreciate everybody tuning in. Hopefully people will make use of this information. So I've identified 8 careers for engineers in the patent field. And so if anybody's like an undergrad, they could probably take advantage of all these. People who are already working, you can take advantage of some of these, maybe even all of them, who knows? So the first career, I think, for engineers in the space of patents and IP is just to be an inventor. Be an inventor or an entrepreneur. And so I have 3 categories. I have the name of the job, then I have, who actually can work this, and I have engineer or scientist. If you have to be an engineer or a scientist to work this job, and then if you need a degree or not, what degree you need. So to be an inventor, you don't have to be an engineer. It's usually an engineer or a scientist, because you have to have some technical knowledge, but you don't have to. You don't have to have a degree. So 2 of the most famous non-degreed engineers are Bill Gates and Mark Zuckerberg. So Bill Gates dropped out of Harvard school. He was, I don't know, maybe a sophomore. And same thing for Zuckerberg. So Bill Gates was actually doing, he was doing computer programming, and when he was 15, him and Paul Allen, I think they formed Microsoft when they were still in high school, and they were doing contract computer programming for I don't know if it was Microsoft back then, but they were doing contract computer programming when they were in high school in Seattle. Early on, they were like, pioneers. They were early programmers. Them and some other friends. And then they got to Harvard, and I don't know if Paul Allen finished, but I know Bill Gates didn't, and so they dropped out and formed Microsoft. So yeah, so to be an inventor, and Zuckerberg the same way. Him and his buddies left. I don't know if they were at Harvard too, but they left and went west and got some capital and got some patents and got into business. So to be an inventor or an entrepreneur, you just have to know how your invention works. You have to know how it works, and that's all you have to do. And you can write it yourself. You can hire a patent attorney, and you can just go. The second thing is fabricator, manufacturer. So a lot of people have ideas for inventions, but don't know how to make them. I had a woman come to me. She had everybody has some pooper scooper idea. She had some idea, but she wasn't a mechanical engineer. She didn't know how to make it. So there's a big desire, there's a big need, and people come to me often with ideas. And everybody wants to send their ideas to China and so on to get made. But if you can figure out how to make people's inventions, and if you partner with a a patent attorney or go to an engineering school and so on, there's a big market for having people create their ideas, and helping people just kind of get into into mass producing or making maybe 100 of their idea and helping them make it better. That's a big aspect for this field. So the only government job I have on here is patent examiner, and so you have to be an engineer or a scientist to be a patent examiner. You need a bachelor of science degree, and that's the starting point very often for the field. A lot of people start off as patent examiner. That's where I started. You don't have to start there, but you can start there. There's a private industry job called patent searcher, and it's usually engineers or scientists who are patent searchers, and usually you have to have a degree, but not always. So there's a whole industry of patent law firms and patent search firms. And patent search firms are when, when two companies, when like say Apple and Samsung are going to war, they're trying to figure out who had the prior patent, like who came up with an idea before the other one did. And so they'll just hire these patent searchers to go out and search what they call the prior art, to search all the patent databases around the world electronically. It's not electronically now, but it's also like a lot of reading, a lot of studying of the technical documents. So patent searchers make a pretty good career. I worked at a firm that had a patent search firm attached to it, and the patent searchers were making 75, 80, 85, 90. They're making good money. That's what patent examiners make. So there's a patent examiner job for the government, and there's a patent searcher job in private industry. Technical specialist is a job where it's a law firm job where a law firm will hire an engineer just to support the law firm's work. And you'll almost learn, it's almost like a paralegal in a sense. You'll learn a lot about patent law, but as an engineer. And I'm going to switch screens, hopefully figure out how to switch screens back to my browser and show you a lot of jobs that are available right now in the patent field. Then there's the job of draftsman illustrator. So those drawings that I showed you of that electrical circuit, there's a huge demand for people who can do CAD design. So I'll show you some patents later of different, more technical inventions. I mean, and these drawings are, I don't do CAD, but so at one firm I worked at, we would draft a new application, and we would charge a client like $6,000 or $7,000 to draft the application. And then we always had $500 set aside for the drawings. And so the inventors would give us their drawings, their, kind of their own markup of their drawings. We would mark it up ourselves and maybe make some changes and then send it to the draftsman, and he would get $500 a pop. And I don't know how big his outfit was or how many clients he had, but that was his full-time job. It's just doing patent drawings. So that's a big aspect of this field. Patent agent is I should have put this in gold. This is the best one. This is the best job for, I shouldn't say the best. Oh man, I lost my back. This is one of the best jobs for engineers in the patent space. The patent agent. I don't know if I can highlight it. Change colors. What color can I make it? I don't know. Patent agent. That's not a great color, but I'll stick with it. Yeah, the patent agent. Patent agent is the best is the best job for engineers in the patent field. So what I do as a patent attorney, when people come to me with a new invention, with a new idea, and they want to get a patent application for it, so I'll take their idea and I'll write it up as you saw before, and I'll write it up and I'll do the drawings and all that, and I'll file it, and then I'll go back and forth with the patent office and negotiate with the patent office, and there's amendments and there's office actions and different things, and I'll get a patent for a person. And I've been doing that for 12 years, and I do it for small companies, for small inventors, and I do it for big companies. But you don't have to be a lawyer to do that. This is the fantastic part. This is the best kept secret in the whole patent field. You don't have to be an attorney to do that. You can be a patent agent. And there's a test that you take called the patent bar. So as a patent attorney, I took 2 bars. I take my state bar, so I can do any kind of law. I can do criminal law, civil law, I can do any kind of law. But I take the patent bar. It's a test administered by the patent office, and I can do patent prosecution in front of the patent office. And only people who take the patent bar can do that. So as a patent attorney, which is the last thing on the list, I can do patent law and I can do other kinds of law. But other attorneys who weren't engineers, who weren't scientists, can't do patent law. So when I was in law school, and like some people would come up to me, they're like, and they found out I was an engineer, and they found out about patent law, They were jealous. They wish they knew about patent law so they could go back to undergrad, get a degree in engineering, and then become patent attorneys. I mean, it's this hidden field, and it's hidden because, like I said before, it's just hidden. Who knows why? Well, I do know why. Like I said earlier. So anyway, as a patent agent, the only people who can take the patent bar are engineers and scientists. So you could be a patent agent and make a lot of money and make good money. And so anybody who's out there listening who's in undergrad, this all these careers are there for you. But if you're a professional engineer, and so you were working as an engineer, not professional engineer like a PE who to test, just somebody who's been working in your field for say 5 years or 10 years, you're like you're probably an expert in your field. You know a lot about your field, more than most people. So if you could find a way, if you know that innovation is being done in your field, if you became a patent agent, you could hire yourself out to different companies in your field, depending on what your employment agreement says, and you can write patent applications in your field, and you could charge whatever you want to. I mean, you can charge. I mean, people charge a lot of good money for patents to write a. I mean, if you write a really good technical document, you could charge 5,000, 6,000, 7,000, or more, depending on how technical it is, depending on your field. But that's what's there for you, and it's just this is the best kept secret in the whole in the patent space. And so then, a patent attorney, you can do everything. As a patent attorney, I can do both. I can go to court. I can do legal opinions. I can do different things. But that's with the law degree, and when I went to law school, it wasn't that expensive. Now it's kind of exorbitant. So I used to always recommend people to go to law school because it's such a good education. But now it's cost prohibitive. So if you're gonna go, fantastic. If not, there's other options for you in the patent field. If you want to be in the patent field. Let's see what's moving on. So, what can be patented? So, okay, that's all kind of the background of where you fit in the patent space. And then, so if someone comes to you, wants to patent something. So there was a case in 1952. Well, there was a Patent Act in 1952 where the language was anything under the sun made by man can be patented. So anything that you can make, you can patent in theory. And that was kind of upheld in 1980. There was this case that 1980 was the era when Exxon and different oil companies were spilling oil into the Gulf of Mexico. And so somebody invented this man-made genetically engineered bacterium that could eat the oil, but it was like a living thing. It was like a living organism, but they made it in a lab. And they got a patent for it, and they were using it, and somebody sued them, I don't know, for infringement, and said you can't patent a living thing, and it went to the Supreme Court, and the court actually said that you can get a patent for it because it was man-made. And so that was a big case in the Supreme Court. And then the second aspect, which is very, very controversial, very important in our current world, is software. So 1972 was a groundbreaking case in the software world. 1972 was a couple of years after the ARPANET, after the internet was discovered, and early, well, the mainframe had been around for a while, but the PC was first starting to come into the mind of the public. People like Apple and so on, they were getting hold of the PC. So there was a case back in 1972, this Goshawk v. Benson, where somebody got a patent for converting binary to decimal in a certain way. It was like a BCD. It was some way of converting, using a computer program to convert binary to decimal and decimal to binary. So everybody who's like an engineer who's done this before knows it is kind of like just a mathematical kind of equation to how to count the bits and add the different columns to get from binary to decimal and back and forth. So this company wrote a program for it and got a patent for it, and someone challenged it. Of course, that's how these cases get to court. And so the court said it was a process claim directed to a numerical algorithm. It was not patentable because the patent would wholly preempt the mathematical formula, and in practical effect, would it be a patent on the algorithm itself. So what they said was that the way that you converted binary to decimal was just like a mathematical equation. They likened it to just math, or just they said, well, you're just doing math. You're just doing math and addition and subtraction. And they said nobody can patent math. They said nobody can patent because math came with the universe, and adding and subtracting came with the universe. So that early case, they associated computer algorithms with math, and that kind of stuck for a while, and it still sticks in the courts. So as it is now, pure software is hard to patent. If you just have a program for doing something, like on a computer or on a smartphone, like an app, it's hard to get a patent for. It's the patent office sees it, they throw up a red flag, and they say it's a 101. There's this rule called 101, this a statute, 35 USC 101, and they say no, that's just an algorithm. It's just an abstract idea. It's just math. You can't get a patent on it. And so right now, to this day, I mean, patent attorneys and patent examiners are, and these cases go to court all the time, are fighting over what can be patented in this software realm. But people still get patents for it, and creative patent agents and patent attorneys find ways to get patents for their companies. But this is a big aspect of patent law right now in terms of software. And it's not gonna change. Software is the future. But I mean, so this is something that's big in the patent field. So let's see, where are we? So let's look at some more patents. Let's look at some things, different patents that have been granted by the patent office, and we'll look at different fields. I'm not sure who's listening, what your background is. We'll look at some different patents and see the things that are patented. Down at the bottom, so these are my stats from February 25th, from this presentation I did a few weeks ago for NSBE Terror Zone Region 2, Johns Hopkins. So, you know, so the patents I'm pulling up are from February 25th. But in that same week, so patents come out every week from the U.S. Patent Office. And so some companies get a lot. So Amazon, in 1 week, got 49 patents. And so if you estimate that a patent costs $10,000 to get, which is a kind of conservative estimate, it may be $20,000, but Amazon got 49 patents in 1 week. So they spent $490,000 in 1 week getting patents. Apple in that same week got 58 patents, so 580,000. But even if you double that, who knows what the actual value is? Because sometimes the patent takes a couple of years to obtain. I mean, that Amazon number might be 800,000, and that Apple, that's just for 1 week. So there's a lot of money in patents. This is my whole. I'm not gonna beat the dead horse. All right, I'm gonna change my screen here. Let's see. Let me see what I can do. Let me see. Share. New share. Let's look at something. Let me see if I can do this. Give me a second here. Oh man, I wasn't set up for this. This is a new challenge. I don't know if I can do it. Let's see. Let's do it this way. No, not there. Man, nope. Let's see this. All right. I'm sure you can see that, right, Maurice? That Zoom?
Yeah, because there's Zoom screen.
All right. This is uspto.gov. This is Patents Gazette. These are the patents that come out every week. Let me see if I can pull this up. Let me see if I can. Let's see. So these are the patents that came out March 17th. Yeah, these are all the patents that came out yesterday. You can see that, Maurice?
Yep.
Yeah. Okay. All right, let's see. Patents by type. This is utility patents. Let's start with A. So these are all the patents that came out with companies that start with A yesterday. And so this is like ABB Schweitz. So that's why I picked that one the other day. See, these are all the patents that came out. This is amazing. This is amazing data. These are all the patents that came out. Some are just by personal people, and then some are by companies. And so let's see. Let's scroll through this. So like Accenture. So Accenture is a computer whatever they do, computer consulting, computer IT, multi-camera object tracking. This is a kind of software, so this is a software patent, or it's kind of camera. It's kind of image processing. It's going to be image processing. So it's going to be a program to access the first video showing 2D scene and blah, blah, blah. They're going to do some image processing. So you can get software patents. I mean, it's possible because Accenture is going to get a bunch of them. Machine learning for authenticating voice. So they're doing some voice processing. And Accenture got another patent yesterday for portable electronic device sales, provisioning, user care, vending, kiosks. People are getting patents for everything. This is my whole point here. So let's scroll down. That's Accenture. Who else is getting patents? Adobe. Adobe is a software company, and they do what they do. Let's see. Gesture-based alignment methodology to extend the viewport on adjacent touchscreen devices. So if you know anything about that, you can get a patent on that. And so this is on and on. This is on and on. You can get a patent. Let me see if I can find the AMD makes computer chips. So this is a substrate. This is a for people who know semiconductors. This is a chip. I used to work in this technology. I know this technology pretty well. This is a ball grid array, and this is a computer. This is like a ceramic substrate, and these are layers in the substrate. And this is a computer chip, and this is this package for redistribution layer structure. This came out yesterday. People have been making patents like this for 30 or 40 years in this area, and they still make them today. And that's the funny thing about patents too, is that old technology never goes out of style. Everybody thinks that they have to work on the cutting edge. They have to work on cybersecurity. They have to work on the cloud. They have to work on artificial intelligence and the smart cars. So all the old technology still exists. People are still getting patents on hammers and nails and things and screws and basic stuff. It's just that the new patents are getting added on to the old patents. So that's like Black & Decker for B. I don't know if they got a patent this week. Yeah, so Black & Decker yesterday got 2 patents for who knows what, for a power tool. So mechanical engineers or whoever, I mean, this is probably mechanical and electrical. So the basic technology still exists. The basic technology, people are making patents for bed frames and for dressers and for water bottles, but they're also getting patents for the high-tech stuff. So whatever your field is, whatever you like to do in engineering or in business, stay in your field. The patents are still there. So anyway, that's kind of, so there's a lot of other, I couldn't pull up all the ones I had set aside. This one I did want to show. This is the USPTO website. So for Facebook, this is a favorite patent of mine. Let me fool around with this for a second. So you can search for patents, and there's a lot of ways of searching for patents. But this is I'm kind of zipping through this, but this is ways to access the patent database, and this is put on by this is a PTO website. This is a PTO website for accessing patents. And there's a lot of information that you can get from this. You can search a lot of patents. You can do a lot of things on this website. I could probably do a whole seminar just on this. So I'm gonna fool around with. I need to get this code for how to get this Facebook patent. This is based on issue date. And I know Facebook got its first patent in 2010, which is amazing, because only a short time ago. I'm gonna look at all the patents they got in 2010 and then pick out their first one. So, I gotta do Facebook and Facebook. So Facebook got 7 patents in 2010. This was their first 7 patents, and their first patent was by our old buddy Mark Zuckerberg et al. These are all of his buddies. They got this first patent, And I'm sure we all know what this patent is. A method for displaying a news feed in a social network environment is described. I mean, they got that's, and I remember reading about this. They got this, a patent on the news feed. It's in the news feed. It's still in existence to this day. And so we can look at this. We got a second. Well, hopefully, my Wi-Fi in my house is okay. My internet is unstable. All right. So we can look at this full patent that Facebook got in 2017, dynamically providing a news feed about a user or a social network. February 23rd, 2010 is Facebook's first patent. And let's see, a method of displaying a news feed. The method includes generating news items regarding activities associated with a user of a social network environment and attaching an informational link associated with at least one of the activities to at least one of the news items, as well as limiting access to the news items to a predetermined set of viewers and assigning an order to the news items. So this is fascinating to me. This is Facebook's first patent, and it's something they still use today, and they can prevent other people from doing it. And that's the power of the patent. Let me see if I can share this screen. Come on. Meeting controls. Nope. Share. This is a yearly chart. I made this myself. Can you see this chart, Maurice?
Yeah, the Excel sheet.
Yeah.
Yep.
So this is a sheet I made a couple months ago showing showing patents for major companies. So this is through going back. So this is right. So the Amazon, Google, Facebook, and Microsoft. These four main ones right here, and then there's other ones too that I was doing some research on. But look at Facebook. They got their first patents in 2010. And then they got, they got 7 patents. And then they got in 2011, they got 8 patents. Then they got 50. Then they got 131. Then they got 290. I mean, last year they got 1,300 patents. And so, what's that? 100 patents is $1 million. 1,000 patents is $10 million, roughly. So they spent $10.3 million. Facebook did in 2019 getting patents. Google, look at Google. Google got their first patent in 2003. And then they're up to they had their peak. They peaked around 2015, 2016. They got 3,000 patents, which is $30 million they spent in patents. And that's just the patents that they got. I mean, that's just in the U.S. I mean, they got patents overseas. So, I mean, I'm being a dead horse, I think, with this patent thing, but this is why we're here. So Amazon got its first patent. They got one back in 99, one in 2002. In 2006, they started exploding and getting more and more, and now they're up to like 2,500 per year. Microsoft is, I mean, this is, and these aren't even the biggest companies per se. Well, Samsung and IBM are the biggest companies. They're just kind of out off the charts, but it's nice to see the growth of these companies in a short time frame. I'm gonna go back to my PowerPoint here. Let me go back to my share. Okay, here we go. Here we go. So, okay. All right, so that's where we are. So, okay. So there's a lot of different kinds of patents. This Airbus one was kind of funny because this Airbus one was just a handle on one of those carts that they move in and out of. When you're in airplanes, they have those little carts for where the stewardesses and the flight attendants keep all the meals and stuff. So the Airbus one was just a handle on one of those carts. I thought that was just amazing that you get a patent. I mean, on the handle. I mean, again, I'm saying everybody's getting cybersecurity information, but you got a patent for a handle on a cart that's used on a plane. So these tech companies are what I was talking about before. And so I'm actually going to use this slide to get a segue into trademarks. I actually did a presentation back on February 14th with some trademark attorneys at the BEA conference in DC. And we talked about trademarks, and it was on Valentine's Day. So we had a bunch of kids we were working with, and we put up just the labels for for different candy companies and had them guess it. And of course, they could guess it. I mean, but the part about trademarks is, if you're in business, you're an entrepreneur, if you have a new idea um, as an engineer, and you want to, you want to market your products, you need a name for your company, and you need a logo. And so all these companies, we don't even need the words here. We all know these logos so well. And so that's the point of trademarks is branding. This is my patent comparisons chart. But so yeah, so the other IP, is trademarks and copyrights and trade secrets. So a trademark, we all know trademarks, I think almost inherently, it's just branding. I mean, it's in our tennis shoes, it's in our bags, all the Louis Vuitton and Prada and Coach. I mean, I think we all know trademarks just from the brands. Everything is a brand. Everything is a brand name. So we're drawn to these aspects of society of the branding. Everything is a private company. So a trademark is a word, phrase, symbol, or design or combination thereof that identifies and distinguishes the source of the goods of one party from those of others. And so there's a chart for, picking a trademark. And so the trademark office is a part of the patent office, is the patent and trademark office. And so they will, when you apply for a trademark, when you apply to be in business, when you want a federally registered trademark, you want to protect your mark across the U.S. and really across the world, because trademark law is a little more international than patent law is. They want your mark to be really different. They don't want a used car company called Used Cars. You can't get a trademark for that, because Used Cars is describing what the invention is or what the product is. So they want you to call your used cars something totally different, So they have this chart here for generic versus fanciful, like a generic. So carpet clean, you couldn't get a trademark for carpet cleaning company, because that's what you do. And if you got that, you'd almost like be preempting anyone else from using those words in their carpet clean. But there'd be so many carpet cleaning companies, you couldn't protect that phrase. And then the next less distinctive is like a descriptive mark. So like American Airlines. So it took American Airlines a while to get a trademark for American Airlines, because it kind of just describes, again, almost, what isn't an American airline? I mean, if you, like Delta is an American airline, so it has to have this secondary meaning. They had to be in business for a while to get this trademark and this colors and their logo and their music, where the people identified it as a separate company called American Airlines before they could get the trademark for American Airlines. So that's descriptive, and that takes a while to get that kind of protection in the market. And then there's a suggestive trademark like Burger King, which, is kind of telling you what it is, but it's still creative in a way. I mean, it's still a creative mark. This is an arbitrary mark like Apple. So Apple, we know Apple now, we all know it as a computer company, but when it was founded, who knows what Apple was? Apple is the name of a fruit, and Macintosh is the name of an apple. But we know Apple Macintosh now is a computer, but back then it was just a mark. It didn't mean anything. So one time I was giving a lecture for some students, and they had like this window they had designed. They had this window, like a 3D window. They had some kind of fancy window, and they were going to call it. They had some version of window. They were calling it like see-through windows. And I told them the story about Apple, and I said, well, it's not, just calling this Windows name isn't creative. It's not really enough. So one of the kids said, oh, so we can call it Pineapple Windows. And I was like, exactly. You call it Pineapple Windows, then you got something, then no one would else, no one would associate, no one else would call their Windows Pineapple but you. And so, it could have a meaning or it couldn't have a meaning, but it's got to be, they wanted to be creative in that way. And then fanciful is like Haagen-Dazs or Exxon, or Nike has a name, it's like a Greek goddess, but a name that doesn't even mean anything. So some creative name, well, Amazon might be arbitrary, but fanciful is like a name that doesn't mean anything. And so those marks are the strongest, because if someone was going to copy you, clearly they're copying you. Clearly they got your name idea from you, and they're copying you. So those are the strongest marks. Those names like Exxon and Amoco, whatever, they're just made up names or made up pictures. And then the copyright is something like an artistic work, like a book or a song or music. And copyright and trademark, actually, you get those protections just by creating something new, just by creating a business and giving it a name and putting it in commerce. You actually get protection for that name just by using it. Same thing with copyright. Copyright, you get protection if you write a song. If you publish something like in print, you get an automatic copyright for that idea just by creating it without even filing it with the government. But patents, on the other hand, patents you actually have to file with the government to get the protection. You can't disclose your idea and protect anyone else from copying it. You have to actually file it with the government and get that government protection that they give you in the Constitution. So that's kind of the basics of IP with a patent heavy focus, because the patents have a lot to do with the engineers, and this is a NSBE presentation. That's kind of the end of this aspect of this presentation. I have another one if I ran short, but I'm kind of on time with this presentation. I have a presentation where I talk about the smartphone as an example of how the smartphone has been created over time with patents, and I break down the different aspects of the patent of the smartphone, like the battery and the microphone and the speaker and the integrated circuits and the chips and the LCD screen. I show how each of these different parts of the smartphone were patented, and how the patent system is used to create technology. And the smartphone goes back almost 200 years. It's a fascinating story, but I'll leave that for another day. So this is my contact information. So this is who I am. I'm the programs chair of the NSBE IP SIG. And this is my email for NSBE, intellectual programs at nesbe.org. And so I have a nonprofit called Endless IP, and where I teach a lot of these lessons to different schools, and I'm raising money for that in the DC area. So my website is endlessip.org, and that's my, oh man, what did I do? Yeah, that's my contact information, my email, Endless IP. And so it's a nonprofit 501c3, and I'm on Twitter and IG and LinkedIn. And so I appreciate everybody for tuning in for this presentation. And if there's any questions, I will happy to try to answer them. Thank you very much.
Hey, Jesse, so far we have one question.
Yeah.
As an engineer and over 5 years experience in my field, where do I start from if I want to be a patent agent?
I would say send me an email, but I'd say look at the, so I mean the USPTO, I would say look it up. I would say look up patent agent. I would say do as much research as you can about being a patent agent. So a patent agent, the patent bar test is actually a test administered by a lot of different, well, it's administered by the PTO, but like the GRE and like the LSAT and like any other standardized test, there are companies that will train you to take and pass the test. And so it's possible to become a patent agent, I should say very easily, but to pass the test, it's a test to pass like any other test. So you can do that. You can do that and take the test and become a patent agent. And the next thing is to get experience as a patent agent. And so if you have connections at a law firm, if you have connections at an engineering firm, if you know people who are patent attorneys who want to teach you some things, if you can learn enough on your own, you can market yourself as a patent agent and do what patent agents do. It's a field that's wide open for engineers. So yeah, so that could answer it in a sense. And then I had this other. Let me see if I can. I'm trying to log into my. Oh yeah, maybe back to my browser. I was gonna show people. Let me see. Back to my browser. Oh, I was gonna show people this link, this job board about. Okay, let me go back to share. Okay. All right. So this is the patent law blog that patent attorneys look at, and this is one of the leading patent law blogs. Can you see that, Maurice, the Patent Leo?
Yep, I see it.
All right. So this is one of the leading. So this is one of the leading patent law blogs in the country, and so they have a job section, and so they used to only advertise for patent attorneys, but now the field is so ripe for technology. There's so many patents being created, so much technology being created, that now they're advertising for patent agents and for technical specialists. So this firm, Clarquist, never heard of it, but it's in the Northwest. They want a biotech patent attorney or an agent. So they're advertising for an attorney or an agent. So a patent agent, somebody who's biotech who has passed the patent agent exam. And so they'll likely hire you. Some of these, if you've got enough technical experience, they'll probably hire you with no experience. If you pass the patent bar and you did well in school and you've got 5 years experience in your field, they'll probably hire you. Um, experience is a patent attorney. So there's a patent attorney blog. So this firm is hiring a patent attorney. This one here, this senior patent engineer, I think this is just a engineer job. So this is this RPS Corporation in San Francisco, seeking a senior patent engineer, electrical engineering. Yeah, they just want an engineer. They're not even looking for an attorney. So they just want people who can understand the technology these days. I mean, this field is like wide open. So they want people who maybe know semiconductors and blah blah blah. You know, if you worked in your field, and maybe they want people with some patent analysis. But if you got good grades and you interview well, so this is for a patent attorney job. This is a patent attorney. This one again, Tyson's Corner. They're looking for a patent attorney or an agent. And since it says telecommute, they probably want somebody with some experience. This is patent litigation. Another one, patent attorney or agent. So there's patent agent jobs out there. And so, and this is kind of new, I think. I think this one, they just want a patent agent, a biotech patent agent. And now we all know that biotech in the future is going to be huge. I mean, with what we're going through right now with the coronavirus, the biotech is definitely going to be a growth area if it wasn't already. She's associate jobs, another patent agent, law firm in Seattle, Washington, Perkins Coie. They're a huge firm, national firm. IP associate. This is a lawyer job, and that's a lawyer job. IP technology litigation associate. I think there's one down here for technical specialist. Oh, here's one, technical specialist. So this firm in Boston, they're looking for a patent agent or a technical specialist. Neither one of these jobs are attorney jobs. So, and that's for biotech, computer science tech. So there's jobs out there for patent agents and for technical specialists, for people who want to be in patents. It's out there. It's a possibility. So I see there's some more questions on there. There's some more questions, Maurice?
Yep. So next question. Why is IP important to Black engineers in NSBE? How would you like to see members act on this information?
I'd like to see, like I said, I'd like to see, I mean, NSBE has no control over undergrad, what people do at undergrad, but maybe they do. I'd like to see NSBE push that, maybe NSBE seniors or maybe seniors from Black colleges, they take their capstone projects and turn them into patent applications. That's one aspect. I mean, for Black engineers, it's no different than for white engineers. The funny thing is, white engineers don't know this either. This is hidden information from the whole engineering world. So in terms of Black excellence, I mean, no, we need to be promoting ourselves. And so I have a whole separate project that I call Return of the Black Inventor, where I bring a lot of the inventions made by historical Black inventors, but even modern. There's modern Black inventors who work at IBM and Ford who have like 30 patents and 40 and 50 patents. So the whole part about patents is about business. Engineering is about business. There's an old expression about the business of engineering is about business, and it is. So your engineering degree it's pure in the sense that it's the math and the science, and we love the engineering, but it's about business, And so patents is about business. Engineering is about business. So the IP is about business. So your engineering degree is about forming companies. So ideally, NSBE it becomes a little more entrepreneurial. I mean, I'm new to NSBE, so that's why I'm kind of bringing this new message. I mean, I was, when I was at Howard, I was in the NSBE chapter, but not really. I mean, to me, Howard University, to have a Black organization, within Howard, I was a little redundant. I didn't understand it. But now as a professional, when you see less people on a regular basis, so I joined DC Professionals, NSBE, and, quickly realized that people didn't know about patents. And I reflected back when I was an undergrad, I didn't know about patents either. But what I found out, unfortunately, is that, in my opinion, NSBE is kind of geared towards, getting jobs instead of creating jobs. And so I think NSBE can shift our focus, not for everybody. I mean, everybody can't come up with a patent and come up with an idea for an invention and have it make a bunch of money. But however, if we take this knowledge for ourselves, that's where the power is. That's the power in society is creating business. And that's why America doesn't like China, because China didn't let Google in. China didn't let Facebook in. They came up with their own Google. I think it's called Baidu or whatever, different, they came up with their own Facebook. So the power in the world is creating business and having people buy your products no matter what your color is. If you're smart, I mean, I went to Carnegie Mellon for a year before I transferred to Howard. Calculus was the same at Carnegie Mellon as it was at Howard. Engineering is the same everywhere. If you could take your ideas and create businesses and have people buy your products, that's where power is, and that's what I'm sharing with. That's what I want to share with Nesby and with anybody that I teach. That's where the power is, and as engineers, that's why I'm hammering this patent thing so hard because as engineers, you have the knowledge to get patents and to have people invest in your ideas and come up with new ideas and get protection and so on and so forth. That's where I see things going.
All right, next question. How can patents get licensed for commercial use or as reference for other ideas?
It's advertising. I mean, licensing is advertising. I mean, there's a lot of people in on. Let me get back to my slide here. Yeah, there's a lot of people in on LinkedIn and different avenues. It's marketing. I mean, so in one aspect, I'd like to see the business schools work with, and then I'd like to see Nesby work with the Black MBAs and the Black attorneys to form businesses, because we all can't work such in isolated silos. Well, if we're not just engineers on um, on our own, we need the business people and the law people to work with us. So it's advertising. It's advertising yourself. It's networking. It's LinkedIn. It's Instagram. And there's a company on Instagram. I saw them at a trade show. I saw them at a presentation. They've got this battery device that they've come up with, and they're marketing themselves. So it's marketing and that kind of thing. I mean, I wish I got an MBA, but I didn't. I got the law and the engineering, but it's marketing. And so you have your idea, and that's the best I can say. It's marketing, Instagram, and LinkedIn. I'm sure there's other ways, but I don't know everything about everything. Yeah, so.
Cool. So next question. Is it wise for chemical engineers and material scientists to get their master's/doctors before going to law school, or would work experience be more valuable?
Um, yeah, the masters and even the chemical and the biotech. You said before going to law school. I mean, that's a lot and work experience. I would say, well, law school is most powerful if you know what you want to do with it. So if you go to law school with the idea of being a patent professional or an IP, then you don't even necessarily need the work experience per se, but a little bit of work experience helps. And the master's degree definitely helped for chemical and biotech. I think for biotech, some firms won't even hire you without a PhD, and I don't know why that is. It's just maybe the level of research and the level of knowledge that you need. But it's hard to get a patent job, even as a patent agent, if you're not a PhD. I think in the biotech and maybe chemistry is the same. But you can do some research in that. You can probably research patent firms and find that out from patent professionals. You send me an email, maybe I could see some links to it. But so for chem bio, at least a master's and some work experience, and just know that that you want to get into IP, and maybe go to a company like what companies get a lot of patents. So and maybe just find a technical company, like a drug company that gets a lot of patents, and see if you can work within their department, maybe even as a patent agent within their department, and you can maybe even just go through the ranks of that department as a patent agent before going to law school and do a lot within there. Maybe they'll pay for law school for you if you really have enough aptitude. But if you're definitely coming into a company these days, patent savvy is really different. I think a lot of people go into companies not being patent savvy and miss that whole world. But if you walk into the company knowing a little bit about it, I think it'll help you out.
All right, next question. Am I restricted to my engineering discipline in terms of intellectual property work?
I'm not sure I understand. No, oh no, you're not. No, so no. So I have a degree in electrical, but I work on everything that I can understand. I would never apply for a job that has like those jobs that we saw, like or chemical or biotech. That's too far for me. That's too far to my understanding. But anything that I could reasonably know or learn. So I do anything electrical, I do anything mechanical, I do anything software related. I do a lot of yeah, anything that I can understand, and I can yeah. If you have an inventor trying to to explain an invention to you, you can ask for more information, or you can go back to your textbooks. But no, you're not restricted to your no, you're not restricted at all. People do it all the time. They transfer people who do mechanical work on electrical work, people who work on people who are chem bio work on electrical stuff. It doesn't even matter. You can work on anything in any field if you can understand it. No, you're not restricted.
All right, next question. I have a PhD in environmental engineering and want to learn more about becoming a patent agent. Where can I find additional information? I think you went through that through the first question, but
No, well, there's a let me go to my share here. There is a well, if you look at patent agent, I think it's PT. There's a the PTO patent agent. They list becoming a patent practitioner. There is a guide that PTO puts out about uh they list I think this is it. They list all the and you all can take down the URL. Can you see that the screen that I'm on? The general requirements bulletin? Maurice?
yes, I see it.
Yeah. All right, so the PTO puts out who can take the patent bar exam. And they list the majors that are just accepted without any further what do you call it? Investigation. So all these majors can take the patent bar exam. These right here, category A. All these people. So if you don't fit within one of these categories, then they have category B or subset, whatever, category B, and they tell you if you have enough hours, like if you have 24 hours in physics, you have 32 hours in a combination of these classes, chemistry, physics, blah, 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 then you can take the exam. So they spell it out for you, the qualifications you need to take if you don't have one of those one of those degrees that's listed above. So if you don't fit category A as the PhD in environmental, maybe you have enough of these courses in category B to qualify, and maybe you have these biology, botany, and then there's another one. So that's I don't know if everybody got that. So that's under the PTO, and then there's an office called. Let me go back. It's called the Office of Enrollment and Discipline. And let's see. So I think it's PTO, OED. And these are the people who actually approve your application. And so these people, you can call them up. And so these are the people who you submit your application to. And they actually tell you, if you weren't one of those major degrees listed in that bulletin, and you have your, you say I got a PhD in environmental, and I think you send them your transcript. Probably you probably send them your transcript. They'll do the evaluation for you. If you can't figure it out yourself, and then so you send them your application, and I don't know, I'm not sure where it is on here. It's on here somewhere about how to apply for it. So yeah, so that's how you do it. You either you have one of those degrees, or you do section B, and you apply for it, and they'll tell you like you have they'll tell you like you're two chemistry classes short of being able to qualify for the test, and you take two more chemistry classes, and then you qualify for the test. That's kind of how it works if you don't fit in those first category.
All right, cool. Next question. What are your thoughts about a graduate student with an idea, question mark, pursue a patent on their own or with their university?
Well, so graduate students very often are funded by the university, so it depends on how much funding you're getting. If you're working for a project that's under the university, if they're paying for your tuition, very likely somewhere you signed some document that said that any ideas you come up with that are related to your work that you're doing for them belongs to them. I mean, that's unfortunate. I mean, a lot of people don't know that, but it's there. And even if you didn't sign something, it's kind of implied. And so every university has an office of what they call technology transfer. And they call it different things in different places. That's kind of what it's called across the board, technology transfer. So, and so if you look on your university's website, I- I'm almost positive. I looked at some university websites. There's a screen, there's a page that tells you the university's policy for coming up with inventions, and it's usually geared towards graduate students and professors. It's not really geared towards undergrads. That's still some gray area for undergrads. Um, but usually the grad students, if you're getting funded by the university, unfortunately, they have a claim to your invention. And if you tried to, get an invention on your own, and they found out later that you did it with under the auspices of them, a piece of it, you could be up for like a legal battle, especially if it's commercially viable. If it doesn't go anywhere, then they might not care. But if you're trying to make some money off of it, and it's so that's the kind of thing you might want to talk to an attorney about and see how you might negotiate it. Or yeah, that could get a little dicey, because if you might work on it and try to not tell them about it and then leave and then work on it yourself. I don't know. That's a little dicey, because very often grad students don't. I mean, you hear these stories for years, and it's true. The professors steal grad students' work, or grad students, work on some idea, but the university takes it, and sometimes that's just what happens. Sometimes that's just the penalty or the downside, for getting your education paid or for having some perk. And sometimes you lose your idea, and that happens. But I'm not saying that happens in every situation, but sometimes that could happen. Um, but it does happen. But I also have a thought too about inventors. My thought about inventors is that it's never one idea that will seal your success. I think inventors always come up with new ideas all the time. So maybe you're working on something now that you might not be able to have full rights to, but when you leave the university, maybe in 5 years you'll have five more ideas. Those are just some thoughts, but yeah, it's look at the technology transfer office webpage for your school and see what it says exactly, and see how and talk to your professor, talk to who you're working for, and find out as much details as you can, and about your status of ideas that you've come up with.
All right, next question. If a typical patent costs around $10,000, how does an engineer who tinkers on the side protect his or her idea? For example, how do you feel about non-disclosures when looking for capital for your invention?
Yeah, well, yeah, non-disclosures are essential. Yeah, non-disclosures are definitely essential. But my first thought is regarding that is that if NSBE, not just NSBE, I'm going to put it all on NSBE, but organizations, or engineers or whoever. So if you can write, and writing isn't a huge emphasis in engineering school. Maybe it could be or should be. If you can write your application yourself, you can file an application yourself. So you can file an application as they call a pro se, as a pro se inventor. It's because pro se is from Latin, meaning on your own. I think it means on your own. So so right now the filing fee, the U.S. filing fee to file a patent application for a micro entity, for somebody who has 5 patents or less, is $430. That's all it is. It's $400, and $430 to file a patent. And so there are pro se inventors. In fact, the USPTO has a program where they help pro se inventors draft patent applications, and some attorneys do as well. And my nonprofit, if we can raise enough money for it, that's one of the goals, is to help inventors, help engineers draft their own patent applications, because and even small firms. I mean, I do some work for some small firms sometimes. The smaller firms won't charge you 10,000; they might charge you 2,000 or whatever for your idea. But the more you can do yourself, the more you can do your own drawings. As I was saying before about the illustrations, the more you can do your own drawings, the more you can do your own description. Then you take it to a patent attorney or a patent agent, whoever, and just maybe do some formatting, maybe just look it over and see if it's okay. And they might just charge you a few $100. So the whole point of me bringing this IP to NSBE is to empower the students to do a lot on their own, that people don't even necessarily know about. But the non-disclosure too is important for anybody that you show it your idea to. And people file like a provisional application, which is a preliminary application. There's different ways to do it. But yeah, well, you always want to have somebody file an NDA, but you really want to develop your idea and file a patent application if you can. Is the goal.
All right, next question. Uh, Patents can be expensive to pursue. Is there funding opportunities for the patent application process?
Not that I know of. But I think that's the venture capital stuff. That's the marketing stuff. That's the networking. But that's the old Shark Tank type stuff where yeah, you try to find an idea and then somebody says, "Do you have a patent?" So it's kind of a chicken and the egg thing. Do they want you to have a patent to get money, or if you have an idea, maybe someone takes your idea. So the capital is always the biggest. That's always the hardest part. And even that even goes back in time. I mean, like Nikola Tesla, he had a bunch of patent ideas, but he had to get Westinghouse to fund it, and so Westinghouse wouldn't always give him as much money as he wanted because he kept inventing. Even Edison, even Thomas Edison, he ran out of money a lot of times, and he had one main backer. J.P. Morgan was his backer because Edison was famous, and Morgan wanted to be affiliated with him. But it's a common malady for inventors not to have the funds, and it's just that constant. It's a constant battle between inventors and investors. It's just a constant relationship, and it's just the more people you know. And so I don't think there's any easy answer for it, because yeah, it's just something you got to just work on.
All right, next question. Can you talk about the different types of patent applications, provisional, utility, design?
Yeah, so utility is what I've been mostly talking about, and in all the pictures I showed, utility patent applications. So a provisional patent application. So the big deal in IP is when you came up with your idea. So there used to be a law in the U.S. where it was you could prove. You can go back 10 years. You had your lab notes. You could prove you've been working on your idea for 10 years. And so if someone filed their application 5 years ago and got a patent for it, you could always come back. And if the PTO said, no, you can't get a patent on your idea because someone came up with it 5 years ago, you can go back to your records and say, no, I did mine 10 years ago. Here's the proof. But that law changed in 2012 for the U.S. And so now it's called first to file. So the old system was called first to invent. And so you prove through lab notes, but now it's called first to file. So the filing date is what governs who came up with the idea first. So it doesn't matter if you've been working on it for 10 years. If you filed it one day after someone else, the person who filed it first gets the priority. And that's for trademarks too. Trademarks is when did you? Well, in trademarks you can prove you've been using it for a while, but the filing date is key. So in the U.S., if you don't have your complete idea, you don't have everything totally 100% perfect, but you have the gist of your idea, you can file what they call a provisional application. And provisional just means temporary. It means something else, but it means temporary. It's like a placeholder. It's a placeholder for that filing date. That filing date is the key thing. To say to the patent office, I came up with this idea on this date, on March 18th, 2020. I'm filing my provisional, and you put as much in that provisional application as you can, as much of the idea as you can, the most drawings, the most technical specs. It doesn't even have to be a great document. It could be like just a term paper or something like that. It doesn't even have to be in any great format. So you just file this provisional as a placeholder, and then you have a year from that day. You have until March 18th, 2021 to file your utility patent application. And your utility, that's your formal patent application that's going to get examined by the patent office. The provisional doesn't get examined at all. It just sits there. It's a permanent record, but it never gets examined. So it never gets, but when you file your non-provisional, your utility, it's called a non-provisional. When you file your non-provisional a year later, that actually gets examined by the patent office for patentability and for other things. So that provisional is just like placeholder for a year for you to establish that filing date that no one else can beat. So you want to get your idea. Some people want to get that idea in very quickly, that provisional. And then within that year, then you have that placeholder. Then you can try to get funding, and you can tell people you have a provisional patent application filed, and you have your filing date, and you can use that for fundraising and for different things. So that's a provisional and a non-provisional that you file a year later. And a design patent is So there's a utility patent describes how something works, how you use something. So you might have like a water bottle, like a like a water bottle for for your bicycle or something like that. And you can say it has a top, it has a bottom, and it has a knob for for drinking water out of. And you can describe it, but it doesn't. It can look any kind of way. It can have a wide knob, it can have a narrow knob. You're just saying it has a knob on top, or it has like a lid. So you're not describing how that lid looks. You're just saying it has this lid and it connects to that knob in a certain way. But anybody, you can make it any way that you want to. You can make it in any configuration. So it doesn't have to look a certain way. So a utility patent governs. Utility is a kind of a word for use. It governs how something is used. A design patent for that water bottle is it's exactly how it looks. So your patent, your design patent is on exactly how a water bottle looks. And I could probably even I could pull up some. But like even you've seen water bottles in like the Fiji water bottle has a certain shape, and you know what the Fiji water bottle looks like. Like even like so every water bottle kind of has its own shape. So it may have a utility patent in a sense on how they made that water bottle, but they'll have a design patent on how that water bottle looks, the shape of it. So that's kind of the difference between utility and design. And so very often companies will get multiple patents because just they want to get as much protection as they can. So Fiji has a design patent for their bottle shape. They have a they have a utility patent. And then they have trademarks. They have trademarks, and some companies get trademarks for the shape as well. They have trademarks for the name. So some companies will just try to get as much IP protection as they can possibly get, and that's just so they have those different kind of patents to govern different kinds of protection.
All right, next question. Not sure if you answered this one already, but concerning intellectual property, what is the dynamic of differentiating between who owns the intellectual property for design created by students during graduate school?
Yeah, right. So we talked about that before. Um, yeah. So I don't know if the person heard that before. So who owns it? For graduate students, very likely the university. I mean, without further examination, very likely the university owns it because graduate students are very often paid by the university for their work and funded. Their work is funded by the university. So there's usually some clause in their employment agreement that says that, and even if it doesn't say it, it's usually spelled out in the technology transfer documents of the university. So you'd have to look at the technology transfer website or go to like I don't know your engineering school or whatever your school is. The dean's office very likely knows the answer to that question. So you have to do some investigation with your grad school and see what their policy is about that because they definitely have a policy.
All right, next question. How does a patent examiner determine whether my invention is patentable?
Oh man, this is fantastic. I got a slide for this. I don't know if I can pull it up. You can see. Let me see. Let me see. It's a compare and contrast. That's not so subjective. It's oh man, I got a great slide. Let me see if I can find it. What did I call this thing? It's a compare and contrast. I didn't know I was gonna get this. Oh, man, where did I put this slide? Well, I was gonna say it's a. Oh, let me. Okay, look. Oh, I got a good one. Let me see. Hold on. I was looking at this a minute ago. Let me see. Uh, where did I put that? All right, one second. That's a great question. That is a fantastic question because that's what everybody does all day long. Man. All right, let me see what search here. Okay, here we go. Let me see if I can share my screen with you here on this thing. All right, here we go. All right, here we go. All right, can you see that 3156, that folder?
Yep.
All right. All right, so this is actually a case I was working on a few weeks ago at my this one law firm I'm affiliated with. So this is, can you see that that drawing? No? You still see the folder?
Yep, still see the folder. You probably have to go to that. You have to do a new share and go to
Okay.
that drawing.
All right. Okay. So here's a drawing for, all right. This is a drawing for an invention for a, so like it's like a server rack. It's a server rack that holds a lot of server blades. And this is a top view. Figure one is a top view. And these are like horizontal and these are vertical. And so there's a space in the middle that air passes through. And this is the actual invention. This is an invention that I wrote for a company. So this is this space in the middle where air can pass through and vent, because these server blades, it's like these blades in a server, and it's a stack of servers, and they get heated up. And so let me see if there's a good so yeah, so here's one area on the left, one area on the right, and the air comes through the middle. And so this is what we submitted, and this is the drawings that we got, and this is kind of a front of a server. And so it's not that technical at all, but their invention is, besides venting air up through the middle of it, they put they put this channel structure. They put this channel structure in the middle of this server apparatus, and they said that they said that the air usually gets vented from the top of the structure first. So they made these thin kind of vents near the top, so that, and they're trying to like equal out the air that gets passed through this channel, so that towards the bottom they made these slits thicker, and to the top they made them narrower. And so then they had these ones on the other side. So they had these horizontal blades, they had these vertical ones, and they had this channel structure in the middle to let the air come through this channel, and have the air be so somewhat equal as it's passing through the channel. And that was their invention. It's basically that channel structure in between these server blades. And then they have fans to bring the air through, and then they can stack them one on top of the other. So that was the invention. So then there's there's the art. So then we send it to the patent office, and then the patent office sends us back their rejection, and they send us prior art to their interpretation of what they found, and they think it's the same, or they think it's close enough. So let me know if you can see this one. I just brought up. Yeah, so can you see this one? It's called Sedaris.
Yep.
You see that one?
Yeah, I see it.
So right. So this is so the patent office will bring this. So they brought this one. Oh, this is the second one they brought against this. Let me go to this other one. So the patent office says a different one. Let's see. This Coglator. Can you see this? Let me see.
Yeah, I can see it.
Coglator?
Yep.
So that was the main one that the patent office came back with. Oh man. Oh man, I lost my. I don't want to close this window. I might lose the whole thing. Oh man, if I close this, I might lose the whole thing. I don't know. Let me see. Okay. Oh, you still got it, Coglator? All right.
Yep.
All right. So this is the first one they came back with, and this was their main. Yeah. So the patent office comes out with this, and they're saying that this thing is the same as ours. Because they have got on the left, they got their server racks on the left, they got the server racks on the right, and then they've got the air coming out the middle. And so on first glance, I was like, oh man, they got us. They got the same thing. And I didn't think ours from the start was that strong. But the client, this is how these patents are. These clients will pay. This is what they want. Who might have turned down the client's money if they want to file for this patent application because they think that they have an invention? So I looked at this prior art from the patent, and so this is what the examiner does. To answer your question, the examiner, he looks out in the technology that exists already, and he finds the closest thing, and he says, yeah, yours is Yours isn't new because these people, this guy Colator did it back in 1987 or whenever this thing came out with, you know. So my job as a patent attorney is I can't just take it on face value that what he's saying is the same as mine. So I had to read this whole thing, and when I read it, what I found out was that this piece, 110B, which points to this little piece here, and 110A, which points to this, is two separate pieces. And I was like, oh, so then I look back at my invention, and I said, well, mine is one piece. Mine's a single piece. So then I go back to the claims, and let me see if I have it. So I go back to the claims, and this is the claims, and I got this. Is this shared? Yeah, so it's still there. So it's still being shared. So these are the claims. So this is the patent part. This is what I'm trying to fight for the patent. So, this isn't. Wait a minute. This is the claims I want. So I changed the claims. Oh man, I don't know if I have it. So these are the claims that were in the case, but then I changed this. So it says one first card. Oh, there it is right there towards the bottom. It's kind of hazy. So I added this language that I have a one-piece channel structure. I have a one-piece channel structure within the middle section to configure the vent air from it. So I just changed my claims. So when the patent office cites something against you that's close to what you have, then you go back to your specification. You go back to what you wrote initially, and you see what's different. So it's this big compare and contrast thing. And I had this game that I show students. I don't know if you all remember, like from 4th grade or from 6th grade or whatever you did it when you were young. They have these pictures where they have like a picture of like a bunch of toys on the left, and then on the right they'll show you the same picture of a bunch of toys, and they'll change a few things. It's like a little game that we all played when we were young, and it's a little, this little, and I have it up somewhere on my computer, but I can't find it right now. So it's just compare and contrast. And so I said I had this one-piece channel structure, and so now he has to go find some one-piece channel structure, and so he'll just try to find that, and if he can't find it, he'll. And I talked to this guy on the phone, and he still tried to say his stuff was good, but we send him a response anyway to the patent office, and he'll respond in a few months. So that's kind of how it is. It's just he goes out and searches and finds the closest thing that he can find to your invention, and tries to match it up, and tries to say it's the same thing, and then you distinguish yours in a little bit. If you distinguish it enough, then you get the patent.
Awesome. And one last question. So back to the website that you were showing us that showed how many patents a company had. How many does Abbott have?
Abbott Labs?
Yes.
Let's see. Where's my? How do I get back to my browser? Okay, 1 second. You see my browser, right?
Yep, I see it.
All right. So go back to uspto.gov, search for patents. I can go to this full database. I can do advanced search, and I can do Assanee/Abbott. This is all their patents ever.
Okay.
It's gonna be a lot. It's gonna be a lot. Well, no, that's not it. Obviously, it's more than 26. So
it's 2 T's. It's 2 T's in Abbott.
What was it? Okay. Yeah, almost 7,000.
Jeez.
Yeah, and you can break it up by year to see it. You can do this issue date, and you can use this this language to do it by year, because who knows how long it goes. And you can do this. So I can do 2019. You can do. So I can 2019 Mr. 0. So I can look for like last year how many they got. So I got 200 last year. So, and then you can do 2018. You can do like a little spreadsheet for yourself if you want to, if you got nothing else to do. 2018 they got 257. Who knows? So who knows if they're up or down? So yeah, there's a lot of everybody's getting patents, and so All
And
right.
that was it for questions. So you can close us out.
All right. Well, yeah, I appreciate everybody tuning in, and I'm glad I looked at the number of people. I think we had like about 30 people, and still 20 people still tuned in. So I appreciate that. And so yeah, for Endless IP, I'm going to try to do some more. Even for next week, I'm going to try to do some more seminars. I'm going to do at every conference. In San Antonio, we've got at least 2 IP seminars. We want to try to have a reception, and we're just trying to let people know about IP, the people that people don't know about it. And we're just trying to grow out the section, and thank everybody for participating.
All right. Thank you.